Hello, my name is Louise and I am Detective Sergeant Haslam of Greater Manchester Police, and I work in the Trafford Safeguarding Unit at Stretford Police Station. And I'd like to be able to talk to you today about domestic violence protection notices and domestic violence protection orders. So to give you a background, the introduction of DVPOs followed a review in 2009 on serial perpetrators of domestic violence. The pilot commenced in 2011 for 1 year with West Mercia, Wiltshire Police and Greater Manchester. And when it ended, it found that DVPOs reduced re-victimisation compared to cases where an arrest had been made but was followed by no further action. The reduction in the re-victimisation was greater when DVPOs were used in cases where there had been 3 or more previous police attendances. The pilot also found that frontline practitioners and victims themselves viewed the DVPOs positively. DVPOs and DVPNs were then rolled out across all 43 police forces in England and Wales from March 2014. DVPOs are a civil order power that fill a gap in providing protection to victims by enabling the police and magistrates' courts to put in place protective measures in the immediate aftermath of a domestic violence incident where there is insufficient evidence to charge a perpetrator and provide protection to a victim via bail conditions. A DVPN is an emergency, non-molestation and eviction notice which can be issued by the police when attending to a domestic abuse incident to a perpetrator. Because the DVPN is a police-issued notice, it is effective from the time of issue, thereby giving the victim the immediate support they require in such a notice. The DVPN can only be considered in circumstances where the perpetrator has been violent or has threatened violence, and that DVPN is then necessary to protect the victim. In terms of the application process, the officer in the case is required to complete the relevant paperwork. This will then be reviewed by the duty inspector to ensure that it has been completed correctly and to the correct standard, and that will then be submitted to our duty superintendent, who will then authorise the DVPN. The DVPN will contain the following exclusions to the perpetrator. So if the perpetrator lives at the property, it will prohibit them from evicting or excluding the AP, it will prohibit them from entering the property, it will require the perpetrator to leave the address, and also to prohibit them from coming within a specified distance. The superintendent will then authorise that application. The superintendent will email the authorised application to the officer in the case and the DVPO team, and that will then be served on to the perpetrator. The DVPOs are based on a 2-step process. Because the DVPN is a police-issued notice, it is effective from the time of issue, thereby giving the victim the immediate support they require in such a situation. This is why the issuing of a DVPN requires the police authorisation at a superintendent rank or above. The inspector will then make sure that on our logs there is allocated to the officers to do welfare checks on the victim and a compliance check with the offender prior to the DVPO being granted at court. The DVPN must state that the constable may arrest a perpetrator without warrant if the constable has reasonable grounds to believe that the perpetrator is in breach of the DVPN. The second step, within 48 hours of the DVPN being served on the perpetrator, an application is then made to the Magistrates' Court for a domestic violence protection order. If the court rules that the victim requires continued protection, they may then issue the DVPO, which can last for a minimum of 14 days to a maximum of 28 days. The district will allocate the officer to then complete the welfare checks with the victims within 24 hours of the DVPO being issued. An officer will complete compliance visits with the perpetrator every 7 days to check that the order is being adhered to. The DAB will remain open for the duration that the order is in place, and all updates and compliance checks will be recorded on the DAB. If there's a breach of the DVPN, the arrested person must be held in custody and brought before the Magistrates Court within 24 hours beginning from the time of arrest, or, if earlier, at the hearing of the DVPO application. There is no separate penalty for breaching the DVPN. The perpetrator may be remanded further if the court were to adjourn. In terms of the breach of the DVPO, it's very similar in that the person arrested must be held in custody and brought before a magistrate's court within 24 hours. GMP Legal Services must be notified when the perpetrator is arrested for breach of a DVPN or DVPO. If the matter is not disposed of, the court may remand the perpetrator. Although the power to issue a DVPN and subsequent application for DVPO lies with the police and ultimately the Criminal Justice Service, the success of any such process will be reliant on the partnership work with other agencies and organisations, including those that contribute to MARAC and service providers for independent domestic violence advocates or other similar services. Engagement with the victim and the agencies at the earliest opportunity is crucial to the success of the DVPN-DVPO process. The DVPO is not a criminal conviction, so whilst they are dealt with before the criminal courts, they are actually a civil offence. But breach of the DVPO is a criminal offence and can result in prison sentences of up to 2 months. A DVPO cannot be extended. 28 days is the maximum amount of time that a magistrate can grant it for. There is no mechanism to appeal, vary or revoke a DVPN or DVPO once made. However, once the DVPO period finishes, the order expires. And it's important to know that a DVPO can be issued without the consent of the victim. There is no right of appeal for the perpetrator. Once the DVPO period finishes, the order expires.